We are here on the Attorney General's original petition and suit affecting the parent-child relationship. Present in the virtual courtroom is Darryl Richmond. Mr. Richmond, are you ready to proceed?
Yes, ma'am.
Also present is Madison Edgar. Are you ready to proceed?
Yes, ma'am.
And representing the Attorney General's office, Ms. Whitney Coons, are you ready to proceed?
Ready, Your Honor.
You may proceed.
Thank you, Your Honor. It's my understanding after meeting with the parties separately that they're in agreement on most issues with the case. It's my understanding the parties agree. There will be a non-disclosure finding for Ms. Edgar and the children's information, that they'll be joint managing conservators, with Ms. Edgar having the right to designate the children's primary residence, that they'll have a visitation exchange at the courthouse in Crowell, Texas, and that they'll do something similar to standard possession, but a little bit different, with Mr. Richmond having the right to visitation with the children every other weekend, weekends determined by Fridays, beginning at 6 p.m. on Friday, ending at 6 p.m. the following Sunday. It would not include the summer provisions or the spring break provisions from the standard possession order, but it would include the holiday provisions. It's also my understanding they agree that Ms. Edgar will be responsible for applying for a government health plan for the children, that Mr. Richmond would pay monthly medical support of $75 per month beginning May 1st of 2024, and guideline child support of $625 per month also beginning May 1st, 2024, and that a step down to $500 per month will be included to go into effect after the first child emancipates. And Your Honor, it's my understanding that the parties are in agreement on all of those issues, and I would ask to call Mr. Richmond, Your Honor.
Okay. Mr. Richmond, please raise your right hand. Do you solemnly swear or affirm that the testimony you provide in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. You may proceed.
Thank you, Your Honor. Mr. Richmond, did you hear and understand all of the terms I announced as agreed to?
Yes.
And did I, in fact, accurately represent what you've agreed to today?
Yes.
And do you believe that this agreement is in the best interest of your children?
Yes.
And you do not have any other minor children besides the children on this case, is that correct?
That's correct.
And we have done the guideline support calculations based on $3,000 per month gross income for you. Do you believe that that accurately reflects what you're earning on average?
Yes.
Okay. And now, do you have an objection to needing to use an app for communications regarding the children?
I mean, yeah, yeah, I do.
Okay. And what do you want the court to know from you when she's considering whether or not an app will be used for communications?
I mean, I'd rather just be civil about it.
Okay. I pass the witness.
Ms. Edgar, do you have any questions of Mr. Richmond?
No.
Okay.
Yeah.
Do you have a question?
Not a question to him directly, other than we both tried to communicate civilly and it hasn't worked out, and so I feel like it would be best and for our children's best interest and our best interest to use the app.
Okay, Ms. Coons.
Your Honor, the state calls Madison Edgar.
Ms. Edgar, will you raise your right hand? Do you solemnly swear or affirm that the testimony you provide in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. You may proceed.
Thank you, Your Honor. Ms. Edgar, did you also hear and understand what I announced to the court as the agreed terms for the order?
Yes, ma'am.
And did it accurately represent what you have agreed to today?
Yes, ma'am.
And do you believe that the agreement is in the best interest of your children?
I do.
In addition to the agreed terms, are you asking that the court order that you and Mr. Richmond download the app close application and use that for all communications regarding the children?
I do.
And do you believe that that would also be in your children's best interests?
I do.
What might the court need to know from you that would help the judge make her determination today about whether or not an app is going to be ordered for communication?
I just have numerous messages of disrespect upon both parties. I think it would keep us both in line and solely speaking about the kids and not allowing external factors to bleed into our co-parenting situation. That's one of our issues, is not being able to get along for our children. And I think it'd be a good way of communicating, holding us both accountable for being civil during communication.
I pass the witness.
Mr. Richmond, do you have any questions of Ms. Edgar?
No, I don't.
Okay. Any other witnesses, Ms. Coons?
No, Your Honor, the state rests.
Okay. On that, I heard agreements about everything. I realize the app is a contested issue. I didn't hear the agreement about, and maybe I just missed it, about retroactive child support.
I apologize, Your Honor. It is my understanding that the parties are in agreement that there be no retroactive child support, and I would just ask to recall both to confirm that.
Okay, go ahead.
Your Honor, the state calls Madison Edgar.
Okay, you are still under oath. You may proceed.
Thank you, Your Honor. And Ms. Edgar, is it correct that you're not wanting any retroactive or back child support to be ordered?
Correct.
I pass the witness.
Okay. Any questions, Mr. Richmond?
No, ma'am.
Okay. Next witness.
Your Honor, the state calls Darryl Richmond.
Mr. Richmond, you are still under oath. You may proceed.
Mr. Richmond, are you also agreeing today that there would be no retroactive or back child support ordered?
Yes, ma'am.
I pass the witness.
Okay. Ms. Edgar, any questions of Mr. Richmond?
No, ma'am.
Okay. And Ms. Coons, do you now close? Rest?
Yes, Your Honor.
Okay. And do you close as well?
Yes, Your Honor, and I'm asking the court approve the agreements of the parties and just request a determination as to whether or not an app will be ordered for communications.
Okay. All right. I will approve the agreements as announced. The agreements made by the parties that will be reduced to an order and submitted to me for signature by Ms. Coons. As to the app close, in this case, I believe you should start with maybe the strictest, and then maybe you can grow out of it. But I will order that all communication regarding possession and access and any updates regarding the children be made through app close. And that is free to both parties. They can download that application and be able to communicate effectively through that app. If at some point you decide by agreement not to use it, that's fine too, but we're going to start with it just to keep everything very focused in on just the children at this time. That is pretty much the only ruling I have made. You've made agreements on everything else. However, if you don't agree with my ruling, you're free to file a motion for new trial by filing a trial de novo with the Knox County District Clerk's Office within the next 3 days. It must be in writing. It must specify the portion of my ruling in which a new hearing is being requested, and notice must go out to all of the parties on the case. I appreciate both of you being here today and reaching those agreements. Good luck in the future with your continued co-parenting and agreements to be made regarding your children. That concludes today's hearing.